Tailor it to something that you need to know rather than my pre-planned remarks. Let me just start with some preliminary information. For those of you who are more recent admittees, keep in mind that when you took the MPRE, the Multi-State Professional Responsibility Exam, you were tested on the ABA model rules, not on California rules. And California has our own unique set of rules of professional conduct. We've been going through an interesting process for more than 12 years where California received, in essence, some pressure to conform to the ABA model structure because there's so much multi-jurisdictional practice these days that makes it difficult for lawyers to know if their duties are different if they're going from state to state. But unfortunately, as of this moment, California has not harmonized our rules with the ABA rules, and our rules are different in certain respects. One of them that affects you is the confidentiality requirements, which I'm going to get into in a minute. But keep your eyes open because the Supreme Court appointed a new Rules Revision Commission this last year, and they are in the process of making recommendations to the Supreme Court for new rules. They will not be the ABA model rules, but they're going to be kind of an amalgam of some of the model rules and some of California's traditional rules. So again, what that means is we're all going to have to learn a completely new set of rules coming up fairly soon. Let me talk to you for a few minutes about California's unique rules on confidentiality. As you all know, we have attorney-client privilege that's set forth in the Evidence Code. Obviously, an Evidence Code provision relates to an evidentiary privilege that can we cannot really hear.
I know, I'm going to get out of the way right now.
What the Evidence Code says is
I'm going to get out of the way.
The client is the holder of the privilege, so it's not the lawyer, it's the client. But the lawyer has a duty to assert the privilege on behalf of the client. Basically, that means any time that you should reasonably conclude what the reasonable lawyer would do, that your client's information should be protected and you should assert the privilege, you have a duty to do so. Now, the privilege can't be waived. It can be waived intentionally, and sometimes it can be waived inadvertently. But the privilege is not waived just because you have available to you someone who can assist the client. In California, the evidentiary privilege includes and protects people who are authorized by your client to assist them in interpreting, in explaining, in providing you ancillary information, and even third parties who you are required to contact to get more information in order to properly represent your client. So you want to be careful when the client brings in someone and wants that person to be present in your communications. Or these days, are you guys doing communications with clients by email at all? Okay, so sometimes somebody's going to copy someone else on the email, and you have to pay attention to that because you need to know who that is and whether it's somebody who is actually under what you might think of as the umbrella of the attorney-client privilege or not. And because if you're not careful, then you could waive the privilege on behalf of the client, and that could have some dire consequences. But in California, in addition to the evidentiary privilege, we also have a separate provision in the Business and Professions Code. So to digress again for a minute, the Supreme Court adopts the rules of professional conduct, and we are all constitutionally officers of the court. That's where that phrase officer of the court comes from, meaning we are under the auspices of the California Supreme Court, and we are required to follow those rules adopted by the court. But in addition, in California, unlike many other states, we are also governed by the legislature. And in the Business and Professions Code, the legislature has adopted a whole separate set of parallel duties that you are also required to maintain. And this has happened sometimes because the legislature has become disenchanted with the State Bar, has felt that the State Bar hasn't done enough to protect the public, hasn't passed rules that the legislature thought should have been passed and required, So in addition to looking at the rules of professional conduct, you also need to read the State Bar Act, which starts at section 6000 of the B&P Code section. There's a section of the B&P Code 6068, which is commonly referred to as the Oath and Duties section. And in subparagraph E, 6068 says that it is the duty of a lawyer to protect client confidences and secrets, even to the lawyer's own peril. And that phrase has been interpreted to be much more extensive than just the evidentiary attorney-client privilege. So we have a duty to protect things that may not be, strictly speaking, privileged, but still constitute client secrets. A good example of this is you learn from your client that your client is a felon. And that, some years ago or even recently the client has been convicted of a felony, which of course is a public record. However, the cases, meaning both Supreme Court cases and State Bar Court disciplinary cases, make clear that even though that information is public, and if somebody knew how to find it or felt that they should look for it, they could discover it. If that information was imparted to you by the client in the attorney-client relationship, then it is deemed to be a client secret, and you may not reveal it, including, and this doesn't affect you all so much, but including if there's a fee dispute later, or you may have reason to withdraw from representation of a client. You have to be sure not to, nilly-willy reveal every bad thing you know about that client, including something that might be found in the public record, because you could be found to have violated your duty to maintain client secrets. Okay, let's talk about some other issues that I think are going to affect your practice here. You are sometimes representing clients who either are not competent to make decisions for themselves, or who you may come to be concerned don't have sufficient capacity to make informed decisions for themselves. The first question that every lawyer needs to ask, regardless of what area you're practicing in, is who is the client? You need to identify, for example, is it a minor child? And is that child capable of making decisions affecting their matter? Or is the client, for example, a guardian ad litem who is there because they've been appointed by the court to be the minor's representative? If you've just got a parent who's not the guardian ad litem, then what happens if the parent wants you to do something that either the child is telling you they don't want to do or don't want you to do, or if you conclude that you don't think the guardian is necessarily acting in the best interest of your client, and you don't want to follow that instruction? Well, there's actually an LA County Bar Ethics opinion that talks about this situation. And I think I referred to the number in your packet of materials, but it's formal opinion 504. And what the opinion concludes, and again, these ethics opinions, they're not authority, it's not a case decision, but they do provide guidance. What the opinion concluded is that a lawyer is ethically obligated to follow the instructions of a minor client to maintain confidential information, and in some respects to follow client instructions. This presents a dilemma sometimes for you as the attorney for a minor, because sometimes a minor will tell you that something bad has happened to them. They've been abused in some way. And then they follow that with, but that's a secret, you can't tell anybody. Now what do you do? This opinion concluded that the lawyer has a duty to maintain the client's confidentiality and follow that instruction, even if the lawyer feels it's not in the client's best interest. So this opinion has elevated the minor client to the same exact level as an adult client would be, and has concluded that, notwithstanding the fact that it's a minor, you would breach your ethical duty if you violated the instruction not to reveal this confidential communication that you've received. But the opinion does give you an out. The opinion says that if the lawyer concludes that the failure of the minor client, did I say client? I meant to say lawyer. If the lawyer concludes that the failure or refusal of the minor client to allow the lawyer to reveal this information about how the client's being damaged so materially affects the relationship that the lawyer feels that their competence, their ability to provide competent representation to this client is impaired, then the lawyer has the option to do a couple things. One would be to ask the court to relieve you as counsel for the minor. Okay, that's a good solution for the lawyer. And if you feel that you're so impaired in providing competent representation that you have to get out of the case, great. Now you're off the hook with your ethics. But that doesn't really help your client much. So, in my view, that's only half an answer, because then, if the court appoints someone else to represent that client, the new lawyer is going to have the same dilemma, or alternatively, maybe the minor won't tell the new lawyer this information. So the other thing that the opinion suggests is that you as the lawyer can go into the court and ask the court to appoint a guardian ad litem for this client. And again, it's a delicate balance, because the opinion says, you can go in, you can make it clear to the court that you feel that your client is not able or doesn't have the capacity to make their reasonable decisions in the matter, but you have to do that without telling the court what is the confidential information. Now, as a practical matter, I don't know how many of you have ever been involved with these kinds of motions before a court to be relieved. Sometimes it comes up in conflict issues where the lawyer says, Your Honor, I have a conflict in this case, and I can't tell you what the basis of the conflict is, because to do so would make me have to waive with my client's privilege, and I can't reveal the confidences. So cases on that topic have said the court has a right to require you as the lawyer to give it some basis. You have to give some reasonable basis for the court to grant this motion. And if you just refuse and say, I can't tell you anything, then you run a real risk that the court's going to say, then I can't grant your motion. So there has to be a way to try to get the information, enough information to the court that the court can understand why it is you're moving either for the appointment of a guardian ad litem or to be relieved as counsel. So again, as a practical matter, one thing that you can do is you can offer a declaration to be filed under seal for in-camera inspection by the court. But that's not a good solution either, because there are cases that say that judges are not permitted to require lawyers to reveal client confidences even in camera. Another thing that I recommend, and especially in the conflict area, or where you think that the court's going to be prejudiced if they know this secret about the client. If the court insists that you have to provide some additional information, you can request that the motion be heard by another judge, not the judge who's going to be determining your client's matter. And that way, at least, you're setting up another layer of insulation, so that if you are, you're between the proverbial rock and a hard place, you've got to make sure your client's protected, or you're going to do your best to do that, but you can't reveal the confidence to the court. You're going to do what you can, again, if nothing else, to send a message to the court that you cannot violate your client's confidentiality. So as you can see, these are difficult issues, and a lot of them are determined on a case-by-case basis. If you find yourself in this situation, my strong recommendation is to talk to someone about it. Go to your supervisor, work in teams, bring it to your team. You might even want to get some independent ethics advice. The State Bar does have a hotline, and sometimes they give you good information. On the other hand, the hotline is run by non-lawyers. They are not permitted to give you legal advice, and there's an old case that is still in effect called Sheffield versus the State Bar, which says that even if you call the hotline, and even if you get advice and you rely on it, that's not a defense to a state bar disciplinary allegation. So you can call the hotline, but you can't rely on the information they give you. Not a great solution. So again, I mean, I think if you find yourself in something that seems to you to be presenting you an ethical dilemma that will adversely affect your representation of the client, don't just try to figure it out on your own. You know, make sure that you maybe get an objective viewpoint on that issue. One other thing on the ethics opinion I want to mention before I move on from it. This opinion 504 also concluded that if you do have a guardian ad litem involved, whether it's somebody that the court has appointed without your request or with your request, this opinion concludes that the lawyer is free to reveal the client's confidences to the guardian ad litem. And normally I would say I agree with that, because the guardian ad litem is the client's representative. In other words, they are the alter ego of the client, if you will. I would put a caveat on it, though, because again, if your client, the minor, is telling you that the alleged wrongdoer is the guardian ad litem, then I think you want to think carefully about what your options are in that instance. And I wouldn't take this part of the opinion to say, well, this gives me free rein to make a revelation of a client's secret that I think is going to hurt the client even more if I were to reveal that I have this information. Okay, so let's talk about decision-making in cases. Who makes what kind of decisions? Generally speaking, you as the lawyer have the discretion to make tactical and strategic decisions. And even if a client tells you, I don't think you should call this witness, I insist that you make this argument to the court. I want you to put this document into evidence. Those kinds of decisions are for the lawyer to make, not the client. So, for example, if your client is insisting that you do something that you know is unethical, you cannot follow that instruction. If your client wants you to take an approach in a case that you don't think is in the client's best interest, you are not required to follow the client's instruction. Now, again, practical tip on this, if you find yourself in this kind of situation, make sure you make a record. I defend lawyers at the state bar, and this comes up, for example, frequently in criminal defense cases, both public defenders and private defense counsel, where after the criminal case is over, typically the client has been convicted, but sometimes not. Sometimes the client was not convicted, but they want their money back. Because if they weren't convicted, after all, there was never, any case against them. And so they'll complain to the bar. And a laundry list of all the things that the lawyer didn't do. I wanted the lawyer to go hire an investigator and do this. I wanted the lawyer to call my best friend who, happens to have a criminal record as long as my arm, and my lawyer refused to put that person on the stand. Those types of things you see commonly in state bar complaints. And the answer is, as the lawyer, I made informed judgments. I formed and carried out a strategy in this case, which in the exercise of my professional judgment, I concluded was in the best interest of my client. Okay? And then the state bar says, well, did you communicate with your client about this judgment and the approach that you decided to take? Because, again, under the rules, we have a duty to communicate with our clients all material developments in the client's matter. Not just the most important ones, but all material developments. And again, going back to my introduction, this duty actually set forth both in the Rules of Professional Conduct, which is Rule 3-500, but also in the B&P Code section in 6068M. So it's an indication how strong the State Bar considers this duty, and the legislature as well. And again, to digress for a moment, I don't know if it would surprise you to hear that the #1 complaint made to the State Bar about lawyers is based on communication issues, not based on conflicts. It's not based on trust funds. It's not based on any of the millions of other things that lawyers get complained about. It's because the client either hasn't heard from the lawyer and therefore has concluded that nothing's being done in their case, or they don't understand what the lawyer's telling them for whatever reason, whether it's a language barrier, lack of sophistication, or often, and I don't know if this affects any of you, but a lot of lawyers, by necessity, use non-lawyer staff to help them communicate with the clients. And that can be a problem. A lot of clients get very upset, and the State Bar isn't crazy about it if the lawyer personally hasn't had direct communication with the client. So, you know, if you have a client who you know is going to have difficulty understanding what's going on in their case, and oftentimes these are the difficult clients, the ones who are combative, the ones who are argumentative, the ones who are rude. And so the natural inclination of the lawyer is to communicate with them less, not more. But that's a bad idea, because this is the client who's going to be more likely to complain about you later. So with this type of client, you want to make sure that you have adequate communication and that some regular aspect of the communication is with you as the lawyer. And there are many easy ways to do this. Again, now that a lot of people are using email, when something happens on a client's case, whether it's a communication from another party, the opposing party, the court, it's easy to just forward that to the client as an FYI. And even people who don't use email, I have always recommended that when you get documents on the client's case, unless it's something that's so minimal that it really doesn't warrant, you know, bothering with, every routine communication should be forwarded to the client, FYI. And you know, people do cover sheets, just check off the box, either for your information or requires your attention or please sign and return to me. Whatever, you can use a simple, you know, single cover sheet and send it to the client. And again, maintain that in your file in some way. It can be maintained electronically. But later, if there's a complaint, either to your supervisor or the State Bar, or heaven forbid, some sort of civil action claim for damages, you have a record that you have kept the client advised of the developments in the client's case. State Bar loves paper. And so when the client is complaining, I never heard from this lawyer, I didn't know what was going on with the case, and we can provide them, the State Bar, with evidence that that's not true, it goes a long way towards refuting other complaints that the client might be making. And that reminds me, I want to also mention that when the State Bar gets a complaint, the State Bar is not limited at all to investigating the complaint that has been made. The State Bar has free rein to investigate any issue that the State Bar concludes may have arisen in connection with this matter. And the complaint can come to the State Bar's attention through multiple means. A judge can complain about an attorney, and that happens fairly frequently. You know, if you're late to the judge's courtroom, if you miss calendar and don't appear at an appearance, if you're sanctioned, or if the judge just is vitriolic and doesn't think you're doing a good job, nothing's going to stop that judge from filing a complaint, and the State Bar takes those complaints seriously because it's a judge. But it could be a newspaper story. The State Bar uses a clipping service. So if you have a case that's somehow, you know, some sort of high publicity case and it gets some press attention, the State Bar can pick that up. So there are multiple ways that the State Bar gets a complaint, and then, as I said, even if it's not something that the complainant raised, if the State Bar sees a different issue, they can require you to respond to that inquiry. And you have a duty to cooperate. Again, part of the B&P code. It is actually a duty of the lawyer to cooperate with the State Bar. So if you get a State Bar inquiry, please take it seriously. Even if you think it's a frivolous complaint, even if you think the client is, you know, nutty, it doesn't matter. You still have a duty to cooperate, and if you don't cooperate with the State Bar, typically that makes them look at you even more closely and be even less favorably inclined to give you the benefit of the doubt, which they're supposed to do. And every fact is supposed to be looked at in the light most reasonable to the lawyer. That doesn't always happen in practice, but that's that's how the case law, establishes the state bar's burden. They have a duty to prove their case by clear and convincing evidence to a reasonable certainty. Obviously a lot higher than a preponderance. But, as a practical matter, given the duty to cooperate, when you get a state bar complaint, it really is incumbent on the lawyer to prove to the state bar that no ethical violation occurred in a matter. Now, moving to other decisions which the lawyer may make, the lawyer makes decisions such as whether to agree to a mistrial. Sometimes you might be asked by opposing party to stipulate to a mistrial or to stipulate to a continuance. Those types of things really call for the lawyer's professional judgment, and the lawyer can make those decisions. There are other things, though, and again, I'm not sure how often this comes up in your particular practice, but the client has fundamental rights that the lawyer cannot usurp, such as the decision whether to waive a trial by jury, the decision whether to settle a case. If it's a fundamental decision that the client may or may not decide to make because of circumstances unique to that client, even if the lawyer thinks the client is wrong, those fundamental decisions nonetheless must be delegated to the client. And there have been cases where if the lawyers have, I'll give you one example which isn't going to affect you directly, but let's talk about personal injury law. Lawyers representing client, the case has been filed, trial is coming up, the client disappears. Client doesn't show for their deposition, and there's a motion for sanctions to dismiss the case because the client has not cooperated in discovery. What is the lawyer supposed to do? Well, it's really a dilemma, because if the lawyer reveals that the client's disappeared, then that's going to put the client in a bad light, both to the opposing counsel and to the court. So here the lawyer has to do a motion to be relieved and has to do it in a way that takes care not to reveal client confidences or prejudices the client. So how about if the lawyer settles the case? Just settle the case, then you don't have to worry about the trial, you'll agree to some reasonable amount for the client, and then when the client shows up, you can give them their money. You can't do it. It seems anomalous, but the rule is you cannot settle the client's case without authority. So again, it creates a dilemma, an ethical dilemma for the lawyer, but the bottom line is, as this situation is unfolding, you're going to want to document your file, you're going to want to make reasonable attempts to try to locate the client, and then when it gets to the point that you can see that the terminating sanctions are barreling towards you like a locomotive, you're going to be able to file a motion to be relieved and feel secure that you did everything you could do up until that point. So I presented to this group a couple years ago, and one of the questions that was asked was, to what extent can you share information that was given to you by your client with the other side of the case? What if the client mentioned something to you in casual conversation and you think that this is something that would help you in your discussions or negotiations with the other side? I don't think there's a bright line answer to this question. Again, you want to use caution. I mean, there are times in the settlement of any case, regardless whether it's a high commercial business dispute or whether you're talking about, some minor issue in a family law matter, that your client might tell you something that, and again, it's the reasonably prudent lawyer standard. If a reasonably prudent lawyer would have recognized that this is something that the client would not want you to share, then you better take care before you reveal that information, because you have a duty to be loyal to the client and also to be competent. And if you're not careful and you reveal something that actually harms the client, you could hold yourself open to not just a bar complaint, but even a negligence complaint. So if you have a question, the easiest thing to do is check with the client. I think it would help you, client, if we could reveal this fact to the other side, and if you would let me negotiate using this information for your goal of achieving X. And if you explain it to the client, and if they consent, again, you're going to make a record, either a note to your file if it's a phone conversation or an email back to the client. And then if the client later has a change of heart, you have done what you needed to do to confirm that you acted within the scope of authority that was given to you by your client. Another question that's come up is, in cases such as those you handle, what is your duty with respect to hiring experts or incurring other costs that you feel are either necessary or helpful to your client's case? Well, you know, this is a hard question when you're talking about government lawyers and when you're talking about lawyers whose clients don't have very many financial resources. What do you do? Well, again, you have to be concerned not only about the financial side, but also about providing competent representation. If you have a case where expert testimony is necessary, then you have to find a way to get expert testimony. If you are incapable of doing that for one reason or another, you know, you try to find a workaround. You know, is there a recipient witness who could also provide testimony on this subject? Is there somebody that you could subpoena without having to pay to get the evidence before the court that you need to produce to the court? Again, if you're having a dilemma of that type that is going to interfere with your ability to provide competent representation, you're going to want to bring that to the court's attention one way or another. If you ever get to the point where you feel that you're not going to be able to provide competent representation, then under the rules, under Rule 3-700 of the Rules of Professional Conduct, you have a duty to bring a motion to the court and seek relief. I was talking earlier about what happens when there's a willful or intentional act by the client which waives confidentiality. I want to talk for a couple of minutes about inadvertent communication of confidential information. It's not that uncommon, as you know, for somebody to accidentally hit reply all when they meant to reply only to their client. Sometimes, whether it's ourselves or our support staff, a document is inadvertently included in a document production which was intended to be pulled and to which a privilege was intended to be asserted. Letters get put in the wrong envelopes. So there's any number of ways when there can be an inadvertent production of confidential information. There isn't a rule on inadvertent production, but there's quite a lot of case law. In a case called Rico versus Mitsubishi, there was disagreement among the lower courts, and the case ultimately worked its way up to the Supreme Court. What happened in that case was a lawyer, after a deposition had concluded for the day, was packing up his briefcase, and the court reporter, who was finishing packing up his or her stuff, handed a document to the lawyer and said, "Can you tell me what exhibit number this is? It doesn't have an exhibit number on it." The lawyer looks at it and sees that it appears to be a memo recording statements made by the opposing party's expert in the case. The deposition of this expert was scheduled for the following week or some other short time. And the lawyer says, "Oh, this isn't an exhibit to the deposition. Can I keep this?" And the court reporter says, "Yes." The lawyer keeps it, doesn't tell anybody. And then when the depo of the expert occurs, and the expert testifies almost diametrically opposed to what the memo indicated that the expert's opinions were, the lawyer whips out the document and uses it to impeach the expert. Opposing counsel goes crazy, brings a motion for sanctions, on the ground that it should have been obvious to this attorney that this was a privileged document, asserting not only attorney-client privilege, but also work product privilege. And as you know, work product privilege is the privilege that belongs to us as lawyers. It's not the client's privilege, it's our privilege. And we as lawyers are the holders of that privilege and have the right to assert it. Now, I'll just digress again for a second to say that rule doesn't apply when you're in a dispute with your own client. And in the BEP code section, or sorry, in the Code of Civil Procedure, where the work product privilege is contained, it makes it clear that if there's an issue of breach of duty between the lawyer and the client, then the client can compel production of work product. But you certainly don't have to produce it to your litigation adversary in a case. So what the lawyer argued in the RICO case is this document, any reasonable lawyer looking at this document would have concluded that this was my work product, my memo of my communications with the expert, and the lawyer should not have read it, should have notified me immediately of the inadvertent production, and should have returned it to me. And the lower courts disagreed. For example, there was a lower court case out of Northern California called Aerojet, which said under fairly similar situations, wait a minute, the primary duty is owed to the client. And if somebody is careless or negligent and allows a privileged document to be disclosed to the other side, that may be malpractice for which the client, the client of that lawyer can sue their own lawyer. But the receiving lawyer has a duty to their own client to use information which is advantageous to their own client. The Supreme Court did not go that way. The Supreme Court said that the duty to respect privileges, whether attorney-client or work product, takes precedent over taking advantage of an inadvertently produced document. And the court said, we're not going to sanction the lawyer because the State Bar doesn't have a rule on this, and there was no notice, and the lower courts were at odds as to what you do. But we are going to rule that what a lawyer has to do in this circumstance is when you see a document that you should recognize, again, or the reasonable lawyer would recognize is privileged, you have to stop reading it immediately, and you have to alert the other side. And at a minimum, you have to put it to the court to decide whether there's been a waiver or not, and that will determine whether you can use whatever the information is in the document, the communication that you've received. And that rule, RICO versus Mitsubishi, has been accepted widely, even beyond its facts, and now I think that it's fairly clear to most legal ethicists that even if it looks to you like a document was deliberately produced, but mistakenly produced, like again, you know, the document's produced and then the day later you get the frantic call from the opposing counsel or the email saying, I want to retract this document, it's privileged, you weren't intended to get it. Generally, it's understood now that you can't ignore that, and you have to, at least, at a minimum, go to the court and get a court ruling that the privilege has been waived. And if you don't, you run the risk of a State Bar complaint and potentially being disqualified from the case or other adverse consequences. What happens if the client is insisting that you act in a manner which would cause you to violate one of the rules of professional conduct? As I mentioned earlier, the rule on termination of representation is Rule 3-700, and it has subsections for permissive withdrawal and for mandatory withdrawal. If you cannot competently represent the client, you don't have an expertise that's being called for in this case, and you cannot come up to speed and become sufficiently expert in that issue, or bring someone else into the case, which you're also entitled to do. If you need to bring in co-counsel who has more expertise than you, then under the rules you can do that without being found to be incompetent. But if you can't do those things, you have an ethical duty to withdraw from representation. Similarly, if the client insists on you doing something that will violate your ethical duty, you have a duty to withdraw from representation. What happens when the client asks you to suborn perjury? Or tells you, I know I told you that I didn't do X, but when I get on the stand, I'm going to testify that I did. You cannot allow that to occur. You may not knowingly allow your client to testify to a false fact, nor can you put a false fact before the court. What happens if you make a representation of fact to the court that you later discover was not accurate? So now it's you. You've made a representation to the court in good faith. You didn't know it was false, but then you learn it was false. Do you have to go back and tell the court? Well, we all have a duty of candor to the court. Separate duty, separate and apart from our duty to the client and our duty to opposing counsel. And again, another duty that's set forth both in the Rules of Professional Conduct, 5-200, and also in the Business and Professions Code 6068. What do you do? Well, although California does have a rule that talks about duty of candor, it doesn't say in the rule what happens if you discover that you have made a misstatement or misrepresentation, but the ABA model rules do talk about this. And cases in California have recognized that although the model rules don't apply here, they don't bind California lawyers, when there is no California rule on point, then we can look to the ABA rules for guidance. And most courts, when they do that, tend to accept what the ABA has determined is the appropriate ethical standard. So in the ABA rule that talks about duties to the court, in one of the comments, the discussion section after the rule, it says there is a duty to go back and correct a factual misstatement that you've made to the court. However, it doesn't last ad infinitum. There is a reasonable termination point where you no longer have that duty, and according to the ABA comment, that's when the case is over. So if you don't discover it until the case is over, then according to the ABA, you don't have an affirmative duty to go back to the court. Yes?
Question. Many times we prepare our clients, we work with them, they're ready to take the stand, they take the stand, and all of a sudden, something else comes out of their mouth.
Right.
The question that I have in that situation where we know there's no fraudulent preparation, there's no perpetrating a fraud on the court that we were aware of, it happens in testimony. But the obligation of the attorney at that point or after that case is done.
Great question. So the obligation of the attorney when the client makes a statement on the stand, unannounced and unanticipated, is to see if you can get the court to permit you to take the client off the stand for a consultation, and you have to counsel the client that they must correct the misstatement that they've made to the court. And if they do, and you can I need to clarify something, Your Honor. May I have, take a little intermission? And if the client gets on the stand and corrects the misstatement, then you're fine. If the client refuses to do so, the rule is you as the lawyer have a duty to maintain the confidentiality of the communications with your client, and you, the lawyer, cannot go back before the court and say, Your Honor, I need to bring to the attention of the court that my client has committed perjury or has made a misstatement of fact or whatever the situation is. But what you do need to do is you need to say, Your Honor, I have now been placed in a conflict situation. I cannot ethically continue to represent the client at this point. And the judge is going to be very unhappy with you when you do that. In the middle of trial, judges are not inclined to hear this, but you have to do it. And the way that I recommend doing it is by referring to the rule itself. So you're going to go look at Rule 3700, and without giving any factual information, Your Honor, I'm required to move the court to be relieved under Rule 3-700. And then you're going to cite the court specifically to the rule. And the judge will get it. The judge will understand it. Yes?
What if the client says something completely different on the stand than what you were expecting, but you really don't know which one is the truth in that?
Did everybody hear that? The client says something completely different than what you expected, but you don't know what the truth is, and you don't know, whether there's any reason to think that this is a false statement. I mean, that happens all the time. How many times in trial have you pulled out your hair because the client has testified to something different than what you thought they were going to say? Well, that doesn't necessarily make it perjury. I mean, again, I think you have to exercise reasonable judgment. If the client says, no, I don't remember, seeing the light turn red, and later and earlier they said, I think I remember that it turned red. I think that there's a gray area where you're talking about client recollection. If you can refresh recollection with some other document or writing, or if you can cure it in some other way, and the client, when they're on the stand, legitimately says, I don't remember, then the chips are just falling where they fall. And I don't think that doesn't rise to the level of a perjurious statement. But where it's something where you're reasonably certain that the client has just made a decision that they're going to testify to an untrue fact because they think it's going to be better for you, then I think we're more in the situation of having a client whose testimony is not correct. And again, that also applies not just to client testimony, but it comes up when lawyers prepare declarations to be submitted in support of motions. And, one I remember from many years ago is a lawyer missed a court appearance because the lawyer's car ran out of gas on the way to the court. And the lawyer did a motion for relief, I don't remember what it was, and reconsideration, and the lawyer said in the declaration, my car had a mechanical problem and was suffering from fuel exhaustion, or something like that. And, you want to be really careful, because you don't want to say something to the court that really is not true. Because not only, can it not have its intended effect, but if the judge concludes that you've made a false statement in a declaration under penalty of perjury, and they bring you in on an OSC raise sanctions and make a state bar complaint, you could have some problems with that. So, generally speaking, I find that if you're going to be doing a declaration, you want to make sure that with anything you put in the declaration, you're going to be comfortable standing before the court in person, looking the judge in the eye and saying, this is what happened, Your Honor. All right. So I think we're getting close to the end. I want to leave some time for questions. Yes?
Sorry. So the department puts in a social work report where my client says, I didn't do X, Y, and Z. That's the department's evidence. My client then tells me, I did do X, Y, and Z. Are you telling me I now have a duty because I know the evidence before the court is not true to tell the judge?
Okay. No, I'm not telling you that. So, again, here we get to this, the tension between client confidentiality and your other duties, and when you have to file a request to be relieved. And I can't recall whether I said this or not, so let me circle back to the first question, which is, client gets on the stand, blurts something out, it's not true. When you take that client out and you counsel the client, you need to make the correction, and the client doesn't do it, and you decide that you have to do something about it, you still know at that point that you have a duty of confidentiality to the client. If there's something that happened in the past, but the client, him or herself, did not commit perjury, then in my view, the duty to maintain client confidentiality will trump other duties. So for example, your client comes to you and says, I committed this crime. That doesn't preclude you as the lawyer from defending the client and putting up the best defense for that client that you can, including using other information to try to impeach, other witnesses and questioning the evidence and so forth. Because your client hasn't gotten on the stand and your client didn't make a perjurious statement. So it's that tension, and it can be difficult, but you have to maintain the client's confidence, and as long as you can still provide ethical representation without yourself asserting a false fact or having the client do it, then you can continue representation. At such point that you are promoting false evidence, then you have to decide, does this now put me at odds with my duty to the client and my duty of candor to the court? And if it does, then you may have to withdraw. You know, the odd thing about this whole area is, and it comes up in the disqualification context, you know, client comes to you, you don't see a conflict, and you represent that client, and then I'll give you an example in a minute, but then the opposite side makes a motion to disqualify you and says, now this lawyer has a conflict because of some information they got from their own client. Well, logically, if the court's going to disqualify the lawyer, then they're going to have to disqualify the next lawyer and the next lawyer after that, because the client is the one that has the information, and the client is the one who's imparting it to their own lawyer. And this comes up, by the way, let me go into conflicts for a second. If you are being called upon to represent more than one client, keep in mind that the representation of multiple clients includes representation of siblings, representation of spouses, representation of parent and child. Anytime you've got more than one client, you have a potential conflict of interest. Under Rule 3310C, if you are representing more than one client, you have a duty to do a written conflict disclosure and get a written consent of the client. And that's true whether or not an actual conflict ever arises between them. And that's because the reasoning is, if you're representing more than one client, there's always the possibility that their interests are going to diverge. They could become at odds with one another. One could do something bad to the other. They could give you conflicting instructions as to what they want you to do in the case. Any number of ways that you could foresee that they might later have disagreements among themselves. And for that reason, you have a duty to make sure they understand up front. You know, if you were represented by a single lawyer, I wouldn't share information with the two of you. If you each had your own lawyer, you could tell your lawyer in confidence, which then the lawyer would not share with the other one. So if you're going to hire me as your joint lawyer, keep in mind, I'm not going to keep confidential from either of you anything that you tell me. Now, I think there is a very narrow category where you could say and reach agreement with clients, although I would venture to say that this should only be done with sophisticated clients who you feel confident are giving you informed consent. That you could say, look, client A is my primary client here, but I'm also representing you, client B. And again, I don't know if this would work in your particular field of law, but say in the business world it comes up where client A has had a long-standing relationship with the lawyer. Client A wants to do a business deal with client B, and they don't want to go to the expense of hiring two different lawyers. So they both come jointly to the lawyer, and the lawyer says, I'll do it. But you'll have to waive the conflict. And in addition to waiving the conflict of hiring me to do this particular transaction, client B, you're going to agree that I'm not required to share with you confidences that I learned from client A, in this matter in which A and B are involved, and I'm not going to share with you, client B, any of the other confidences that I have with client A on unrelated matters. And in my opinion, those kinds of conflict waivers will work because they make sense. And if you can show that you gave sufficient disclosure to B, and B had an opportunity to seek independent legal advice, B's not required to seek independent legal advice, but if they've had an opportunity to do so and they consent in writing, then you should be fine. And you can also do prospective waivers, even if you don't foresee this kind of situation, but it's always possible that a conflict could arise. You could say, you both agree, A and B, that if a conflict arises between you, that I can continue representing one of you, even if the other one decides that they want to go get separate independent counsel to represent them. Now, as a practical matter, those kinds of provisions can get sticky, Because when the conflict does arise, and now the clients hate each other, they will really scream and yell about whether that advance waiver of an unknown prospective conflict could ever have been informed. And that brings me to the last case that I want to talk about today, which, you know, as an ethics nerd, I find really fascinating. The case is called Shepard Mullin versus JM Manufacturing. Shepard Mullin represented a city, and in various things, sort of intermittently over the years. Whenever this city needed some work, they'd come to this one department at Shepard Mullin that specialized in, you know, municipality law, and they would get represented. Nothing was pending at the time that Shepard Mullin was hired by JM Manufacturing in a case. So Shepard did a conflict check, nothing was there, and also they had a conflict waiver, sort of a standard global conflict waiver like a lot of firms have in their retainer agreements with clients, which say, you understand, we represent a lot of clients in your industry, and you agree that we can represent other clients in matters that are unrelated to you, not related to this dispute rather, even if we're representing you. And it said in the waiver explicitly, you agree that you are waiving the duty of loyalty that we would otherwise owe you. And the California Supreme Court has described the duty of loyalty in extremely broad terms, and it essentially says, if you represent a client in anything, you are prohibited from representing an adversary to that client in anything, even if it's totally unrelated to the matter in which you represent the client, and you haven't gained any confidential information that could be used against the client or imparted to this other adverse party, unless you get informed written consent. So Shepard's representing JM, and then the city comes back to the other department at Shepard Mullin to represent it in something. JM doesn't know about it. Shepard finishes representing JM, and a fee dispute arises. So Shepard Mullin sues JM for a lot of money. I think it's more than $2 million. And JM says, aha, we're not going to pay you, and we're going to ask the court to make you disgorge all the $1 million we paid you already because you had a conflict. You accepted representation of this municipality, and the municipality was an intervener in a key TAM action in which you were representing us, therefore you had a conflict, we didn't waive it, and conflict tainted representation is worth zero, give us back our money. And there was an arbitration clause, they went to arbitration, the arbitrator said no, you have to pay your legal fee. They then took it to affirm it as a Superior Court judgment, it was raised again, Superior Court said no, you have to pay your fee. Then they went to the appellate court, and the appellate court said, wait a minute, you didn't go back to JM when you accepted the municipality as a client in this totally unrelated matter, and therefore the conflict waiver they gave you at the beginning of representation could not have been informed, it was not effective. And in order to get informed consent, you should have gone back to the client, JM, at the later point and gotten a new conflict waiver from them. Now, that means that there's no such thing as an advance waiver, because what's the point of it if it's not effective and you have to go back to the client later? So this, decision has been appealed by Shepard Mullin to the California Supreme Court, and the Supreme Court has accepted the appeal. And there have been many amicus briefs filed on behalf of Shepard Mullin in this case. You know, with the idea that now, you know, you all may not always work here. You know, you may move and work for another agency or a different firm. And if you're working at a firm, you may move. There are all kinds of conflicts that can arise as lawyers, you know, mobility increases. And, well, maybe you'll never work anywhere else. But you know, even here, if the time comes when, and now making, again, my point about the conflict issue, if the time comes where you are asked to represent more than one client, you need to make the decision and make it clear. You need to either say, I'm not going to do that, and because of what I can see as the real possibility that there will be conflicts between you in the future, I'm going to only advise one of you, and the other one of you go get your own counsel. And again, I don't have time to talk at great length about screening, but another very hot button issue is whether you can ever have screening. So can you ever have lawyers who either were tainted by an old conflict or who currently in the same firm be ethically screened? Can an ethical wall be built to isolate them one from the other, to guard against the possibility that they're sharing confidences? And if so, what kind of screen has to be constructed? What kind of consent has to be given by the clients? And will that be upheld if one of the clients later objects? But at least if you see coming down the pike a real likelihood of a conflict of interest, then you need to first identify who the client is and who it is not, and get a conflict waiver which says what you can reasonably foresee you will want to do when the conflict arises in the future. And I think I said, but in case I didn't, the third option is that you'll say to them, if a conflict arises between you, I'm out. I'm going to withdraw from representing both of you, and then you're each going to have to go out and get independent counsel. So, you know, when that conflict does arise, if you conclude that the conflict between these clients is so direct and so serious and, you know, so difficult, then it may be that you are doing the best thing not only for yourself but for the clients to just step away and say, at this point, your interests are so diverse and so unreconcilable that you need to go get independent legal counsel. And if you need to move the court to be relieved, then that may be what you need to do. All right, questions?
Is it enough for the attorney to advise the client of this potential conflict? For example, we have cases where a mother will have a child with one man, and then years later come back and there's another father, another child, but with the same